নতুন কোড লাগিছে এজেন্ট এখন আঁতৰাই দিয়াৰ লগে লগে মই এক নম্বৰবোৰ আছে
OPP আছে গমে পোৱা নাই দৌৰ কি হ'ব পাপা আইটেম মাতি দিবতো বহি যাব দেখোন
আছো তাৰ বাহিৰতে আছো এতিয়া আপোনাৰ হেৰি
আমাৰ নালাগে তাৰপৰা মাতিব
कॉपी लो चाहे 10 मिनट दे दो
कैसे
10 मिनट बैठ इसका ना एक वो है
Good morning, Lordship.
Good morning.
There is delivery of order. Item number 1, bail application 3329 of 2023.
Bail is rejected, but the trial court is directed to take measures to make every endeavor to commence the trial at least against the appearing accused persons. And if trial is procrastinated any further, the petitioner is at liberty to apply for bail, which may be considered by the court as per merits of the case.
Item number 2, bail application 4377 of 23.
This case also bail is rejected. The trial court may make every endeavor to expedite the trial for speedy disposal of the trial. On further procrastination of the trial, the petitioner is at liberty to, just a moment.
Item number 3, bail application 4531 of 23.
Sushma कौन है?
Bail is rejected at this junction. Rejected.
Sushma.
Item number 4 for motion.
May I please your lordship?
Yes.
439 application lordship.
Mm,
Petitioner was shown arrested on 1/2/2024 lordship.
mm,
In this case, lordship, the petitioners were arrested in connection with Jajoria PS case number 3/24 on 19/2/2024,
mm,
which was registered under section 120B 466 468 471.
mm,
Then in this case, that was in Nagaon lordship.
mm,
Then in this case, lordship, we arrested on 1/2/2024. Today is about 26 days, lordship.
mm.
FIR will, lordship, get that page number, lordship, 12. The petitioner were not named in the FIR, lordship.
Mm.
Though Mazharul is there, lordship.
Mm.
One Mazharul Islam is named in the FIR, but his father's name is different, and he has granted bail, lordship, by this honorable court earlier. He was arrested earlier, and he has been released, my lord. Then these persons were shown arrested, lordship. They are not named at all in this case, lordship, merely because of suspicion, lordship, because the allegation is in the Zazoria PS case, lordship, that are similar to this case. That is why, lordship, they were on merely on suspicion, they were arrested, lordship.
So earlier I had rejected the bail.
No, actually, I think, lordship, there is a direction from the apex court that if any court pass any order, then this should be
And
listed.
Same
Yes,
case.
lordship passed same case. Lordship passed the order regarding Umar Farooq, Wasim Akram, who is named in the FIR, and Mazharul Islam and others also. So
So they were
I have the copy. Lord.
They were granted or rejected. They were
Granted.
So what do you have to say? Public proceedings.
Lordship, CD is necessary, Lordship, to ascertain the truth of the facts of the case, Lordship.
Mm. So within a short date, we'll call for the CD.
Lordship. CD may be called for, Lordship.
Can it be sorted because since 1901 they were in.
This is from Jajoria. How far is Jajoria? Under which district? Let me see.
Lordship?
How far is Jajoria? Under which district? Morigaon.
No, Jajoria is from Nagaon, Lordship.
Nagaon. So how long will this?
Jajori PS, case number 3, Lordship. I have written in my petition.
Jajori. Okay.
Jajori, Lord. It's from Nagaon.
How long will this CD take? From Nagaon? 1 week or?
8 March, Lordship.
Can it be earlier than that, Lordship? Because
from Morigaon, Lordship.
Lord, it's Morigaon near to Gauhati, Lordship. It is actually they are inside jail since 19/1/2024 in a main case. In that case, Lordship, they got bail from the trial court, Lordship. Only in this case, they are inside the jail in which they were shown arrested, Lordship.
So
for about 26 days, they are.
Otherwise, Lordship, if the CD will not come, again I have to call Lordship.
That will come, Lordship, I think, because other cases are pending. Can it be next week, any date, Lordship?
Next week, okay. You suggest a date, PP and
any
7, Lordship, 7.
Huh?
7th of March.
All right, I'll need a secretary to type the order. Nobody's around.
Oh.
7 March.
7.
7, Lord.
So you can tell her to just write down, call for a CD, list the matter on 7 March.
7 March, Thursday.
In connection with this case.
Can it be on Wednesday, Lordship?
Well,
6.
What is the date? 6.
6. Okay, Lord. 6 March.
All right. Wednesday.
Obliged, your Lordship.
Albert, you can ask the secretary to call for the CD.
Lordship, order to type করার লব লাগিব। ঠিক আছে,
call.
thank you, Lordship.
ঠিক আছে, ঠিক আছে। CD is the matter on. Yes. 6-3. All right.
Eight.
Lordship,
Huh? Yes. Something went off. The voice went off. Maybe. I have a division bench now. Thereafter, after the division bench. This is the record.
Court Master sir? Court Master sir, can you hear us?
There is a DB and after that single bench.
Thank you. How long, usually how long the DB will take? 10-15 minutes or more than that?
Can say it depends on the IA.
Ugh.
You check through the net, na DB.
Hmm. Ah.
This matter, actually, I'm not, other cases reported, but.
Item number 3.
Madam.
All right.
It's never been a referent for the respondent, madam.
Okay.
This matter may come on 18th of March.
Learned Counsel, Mr.
SK meeting.
SK Medi is present on behalf of the petitioner, and Learned Senior Counsel, Mr. IMT Longshire is present on behalf of the respondent. List the matter as
Okay,
agreed.
18
The Learned Counsel for the petitioner has prayed for adjournment. List the matter on 18 March.
18,
My lord, on
Oh,
19/1/2024.
just a moment. I'll have to dictate again.
Yes, it's all right, my lord. On 19/1/2024,
Hmm.
my learned friend have filed one additional affidavit. It was
This
not-
item number 3.
Yes, it
Ah.
was not brought
Record.
on record.
on,
Yes, can be brought on record.
one of the, if it is on record, let that be.
I'll have to bring it on record. Or I'll have to include it in the order.
Yes, ma'am.
Yes.
It is a little bit come record.
Okay.
I
Learned,
received
item
the
number 3.
additional affidavit.
Learned Counsel Mr. S.K. Mehdi is present on behalf of the petitioner, and Learned Senior Counsel Mr. I.M.T. Longchar is present on behalf of the respondents.
Yes. so-
One respondent, so
Yes,
is
so-
present on behalf of the respondent and has submitted the
The additional affidavit filed by me, my lord, is not in record, my lord. So, maybe,
Oh, you have filed the additional
yes,
affidavit.
my lord, I filed.
Oh, and has submitted, is strike it off. Is present on behalf of the respondents, full stop. The learned, counsel for the petitioner has filed an additional
Yes,
affidavit.
madam.
The receipt to place the affidavit on record. This is what you want.
My lord, I have not checked, lord,
I'm referring to 19/1/2024.
there's an order, my lord,
Yes.
earlier, there's some delay, my lord, to explain delay, I filed additional affidavit, my lord.
Hmm.
And my senior friend, especially, it is not in record, I don't know whether it is record or not.
Additional affidavit.
Yes, madam.
Just the last sentence, don't type the last sentence.
It's fine. Additional.
Yes, yes.
It is there.
Yes, yes.
Okay. File on 18, madam.
Place the matter on 18(3). The last sentence, strike it off.
Fix, my lord.
Take sense.
Yes, list the matter on 18(3).
Much.
Yeah, Mr. Lordship,
Hmm.
Lordship, I did item number 7.
Hmm.
I am appealing for respondent number 2, 3, and 4, Lordship. The affidavit is ready, Lordship. I'll be filing by tomorrow, Lordship. So,
Learned government advocate
no, Lordship, engaged counsel.
or learned counsel for the
Respondent number 2, 3, and 4,
respondents number 2, 3, and 4
Lordship.
has prayed for time to submit additional affidavit.
Affidavit number 6.
Affidavit in opposition. List the matter after how much? List the matter after 3 weeks.
Obliged, Lordship.
May I please show, Lordship, I beg to mention item number 17 and 18, Lordship.
17 and 18, yes.
Does it come up after 3 weeks, Lordship?
Ah,
Worship, here I'm led by Mr. Senior Advocate H. Rahman, and he's from Gauhati.
hmm.
So I pray date may be given to us.
All right. Learned counsel for the respondent, Mr.
Siddhi Rumsun.
C.D. Rung Singh has prayed for time, prayed for adjournment with learned counsel, Mr. C.D. Rung Singh, with the consent of the other side, has prayed for adjournment. List the matter on, you want a date? 3 weeks date.
Worship,
Ah.
if it can be listed on March 26th.
Is it okay? 26 March.
Right.
Yeah, please, Your Lordship. Maybe please to mention item number 10, Your Lordship.
Hmm.
Item
Yes.
10.
Yes.
Your Lordship, here I need to receive instruction, so another 3 weeks may be granted to me.
Government
For filing
advocate,
contract with, for the government, yes, state government.
learned government advocate, Nagaland, Miss, your good name?
Yes, Your Lordship. I'm asking.
Your
for-
good name?
Livika, Your Lordship.
With the consent of the other side, has paid for time to file
Affidavit, Your Lordship.
affidavit
Yes, Your Lordship.
in opposition.
Yes, Your Lordship. Affidavit
Affidavit.
in opposition.
Affidavit in opposition, list the matter after
After
3
3
weeks.
weeks, Your Lordship. Much obliged.
Yes, Lordship. Lordship, I beg to mention item number 6.
Yes,
Lordship, we have filed RTI to we have received it, so kindly give grant us 2 weeks time to file it, that will reply.
learned counsel, Miss learned counsel for the petitioner, C.
Appeal,
Able IME, with the consent of the other side, has paid for time to file affidavit in reply.
yes, Lordship.
List the matter after 3 weeks,
2 weeks. Lordship.
2 weeks.
Till this, madam.
Hmm.
I'd like to mention one matter, bail application 1 of 2024, came up on last Friday, and it was supposed to get listed today, but then it has not been listed. So it can be taken up as last item today. I have been informed that the seat has been
If
received.
possible, yes. If time permits, why not?
Obliged.
My Lordship.
Hmm.
Item number 9.
Hmm.
I'll be filing my affidavit in course of days. So if it kindly come up this later next week. Yes.
Learned Government Advocate Nagaland C. So Mr. So with the consent of with the consent of the other side, has prayed for time to file affidavit in opposition. List the matter after 1 week.
1 week.
Mm.
This motion. My lord, I beg to mention item number 20.
Mm.
Hearing item number 20.
Mm.
May it be listed after 3 weeks now. We are for respondent number 5.
Learned Counsel, Mr.
Pisoto.
B. Soto. For the respondent number 5 with the consent of the other side,
No, my lord.
you have taken
But
consent.
from them.
Has prayed for with the stack up with the consent of the other side. Don't include with the consent of the other side. Has prayed for adjournment. List the matter
After 3 weeks.
for what? What is the reason to pray for adjournment?
My lord, my senior is not keeping well.
Okay. As the learned senior, as his senior counsel is not well. As his senior as the senior counsel is not well. Who is not well? Mr.
Yes, no.
As learned counsel, Mr. A. Jimomi is not well. List the matter after
After 3 weeks.
3 weeks.
Not Ijimomi. Iejo. Iejo.
Item number 20.
Mm.
Yes, please write down the name.
My son.
Please, your lordship,
Mm.
I beg to mention item number 4. Here the parties has compromised.
Mm.
However, we are yet to receive signature from the department. So kindly grant us 1 week time, lordship.
Learned counsel, Miss
K. Lily Su for respondent number 1.
K. Lily Su. K. Lily Su for the respondent number 1 has submitted that the matter has been settled amicably between both the parties and what is the reason? And the signatures
yet
are to
to-
be and the signatures of both the parties are to be obtained. List the matter after
1 week.
1 week.
Much obliged. May I please, your lordship?
Mm.
Lordship, I beg to mention item number 13.
Mm.
I am yet to file my bakalat na my lordship. I'm for private respondent number 6. 13.
Learned counsel, Miss
Nancy Lota.
Nancy Lota
Yes, your lordship.
has appeared today for respondent number 6
Yes, your
and has
lordship.
prayed for time to file her wakalat number. List the matter when do you want?
3 weeks, your lordship.
3 weeks,
Lordship,
okay.
there is an interim.
List the matter after 3 weeks. Interim order shall remain in force till then.
Lordship, item number 14.
Mm.
The same matter, we are yet to file our reply.
Mm.
So kindly give us the same time, 3 weeks.
Learned counsel, Miss Nancy Lota for the respondent number
6.
6 has prayed for 3 weeks time to file the reply.
Yes, your lordship.
File the affidavit in reply.
Yes, your lordship.
File affidavit in reply. List the matter after 3 weeks.
Oblige, your lordship.
So I beg to mention hearing item number 15.
Yes.
If I pray that the matter may be passed over.
All right. You are for the petitioner. Your good name? Learned counsel, Mr. So-and-so has submitted to pass over the matter for the day. List the matter after 1 week. With the consent of the other side, just include with the consent of the other side.
The matter may be listed tomorrow.
Okay. List the matter on, what is tomorrow, 27th? On tomorrow, 27th. 27th too.
What if I have similar prayer for item number 19?
Mm.
This may also be listed tomorrow.
Same prayer. Same order.
Lordship, item number 16, I pray that the matter may be listed after 3 weeks.
Learned counsel, Mr. So-and-so, with the consent of the other side. Have you taken the consent of the other side?
Yes.
with the consent of the other side, has prayed for adjournment, list the matter after 3 weeks.
Item number 2, filing granted 3 weeks time to file affidavit in reply to the affidavit proposal filed by the government as well as the private respondents.
Item number?
2.
Learned counsel, Mr. So and so, with the consent of the other side, has paid for time to file affidavit. List the matter after 2 weeks, 3 weeks.
Video list.
My lord,
Mm,
the item 25.
Mm.
My lord, this issue is for the withdrawal.
mm.
And that is mentioned in the.
Yes. He wanted to withdraw, but he
Yes,
was
Your
not
Honor.
willing. Mm.
My lord,
He has resisted the withdrawal, yes. Yes.
your, my client instructed me to withdraw. It seems there's some lapse of something, so they suggested that to be withdrawn.
Please give me the file, yes. So he was asking for liberty. He has only objected to the liberty to file fresh
Your
The
Honor, yes.
writ petition.
in regard-
Otherwise, he has no objection if the matter is
Yeah, in
withdrawn.
regard to liberty, whatever it may be, I cannot go beyond the procedure of the.
Yes,
law.
of course.
My humble prayer for withdrawal is that the lapse which is having in the party,
Mm.
so their own seems process, so he instructed me to withdraw.
Learned counsel, Mr.
Your, well, I'm coming,
Kame Elin Rongme
your,
has submitted that the petitioner the petitioner is willing to withdraw the petition. Learned counsel, Mr. Takamasa.
assisted by CB.
A learned senior counsel, Mr. Takamasa, assisted by her learned counsel, Mr. Takamasa. Senior counsel, learned senior counsel, Mr. Takamasa, assisted by learned counsel, Mr. Sentilong. Petition is dismissed on withdrawal or disposed of on
May
withdrawal.
allow to withdraw.
Petition is
Dismiss on withdrawal without liberty lodged.
petition is disposed of on withdrawal.
Yes, Lord.
Matter is closed. All right, this will suffice.
Yeah, lordship may be because
Mm.
I cannot go beyond the law.
Yeah, of course,
permitted.
yes. Disposed of on withdrawal, yes. Matter is closed. Anything else?
Lordship, yes.
Addition or any tinkering? No.
Your-
Of the order? No. All right.
Oh, motion, item number 1.
Hmm.
The applicant is going for the. For bills. On bill of the accused with the second one, Your Lordship, the honor. Here the applicant says that the accused is the husband of the applicant, Your Lordship.
Husband of the applicant.
Yes, Lordship. He was arrested on 28/2023 by the Timapur East Police Station in Timapur
Hmm.
in connection with one GR number 49 of 2023, Your Honor. That is police case number 6 of 2023
Hmm.
in connection with GR doing 49 of 2023.
So he was arrested in the month of August.
Yes, Lordship.
So where is the government? Where is the public prosecutor? Yes. He was arrested in the month of August
Yes.
and now it's 4, 5,
It's 189 days after today.
189 days.
Yes, Lord.
So do you have the CD? Any charge
No.
sheet has been submitted?
No, Your Lordship, at this stage, let notice go.
Do you know that charge sheet has been submitted?
Search that is found.
That
You do not know.
Not yet.
So you'll obtain instructions whether charge sheet
Yes,
has been
yes.
submitted? So today or tomorrow?
No, Your Lordship, let it be on 29th.
29th.
Yes.
29th.
Your Honor, that is the Lordship, I was going for 48 days, Your Lordship.
Because if charge sheet is not submitted,
Lordship.
then if we prolong the matter for such a long time,
Lordship.
then that it will go against the
Lordship. So just a short time, Your Lordship, on 29th.
tomorrow.
Lordship, petition has been served to me just before I entered the court. So, Your Lordship,
29 will be too long because that
no,
it will be against violation of it will be against violation of human rights. 29 will be
Lordship.
if charge sheet is not submitted.
on 28th, Your Lordship, then. Please.
Yes, 28.
Yes.
Heard, Mr.
So much you
Mr. So-and-so, learned counsel for the petitioner, and Miss
S. Lering.
Learned PP, Nagaland. The petitioner is the father of the accused who is behind bars for 189 days in connection with so-and-so PS case under so-and-so sections. It is submitted that the petitioner is that the petitioner as well as the learned PP is not aware if charge sheet has been laid against the petitioner. The learned PP has prayed for time to obtain instructions or to obtain the CD to find out if charge sheet has been laid against the petitioner. List the matter on 28. Meanwhile, call for the CD then.
Lordship.
Your Honor, the petitioner, she's the wife of the accused, not the father.
Oh, wife of the
Obligation.
petitioner is the wife of the accused who is behind bars.
From the supplementary cost list for motion item number 21.
May I please, your ladyship, can your ladyship hear me?
Hmm.
I'm appearing virtually.
Hmm.
Your ladyship, I appear for the petitioner in this matter. This petition has been filed primarily for the quashing of summons that have been issued by the learned trial court against Mr. Rajiv Bhatnagar, your ladyship, the petitioner here. Your ladyship will have the petition, the summons that have been issued, your ladyship, at page 427 of the paper book. Your ladyship are with me? Ladyship will see that the summons have been issued to Shri Rajiv Bhatnagar, IRP of Green Lighting Private Limited. Now, your ladyship, there are two aspects that I wish to submit with respect to these summons. Firstly, your ladyship, the company Green Lighting Private Limited, which is the accused number 1 before the learned trial court, this company is currently under corporate insolvency, your ladyship, under the Insolvency and Bankruptcy Code. Now, your ladyship is aware that under the Insolvency and Bankruptcy Code, there's a provision of moratorium under section 14, which creates a prohibition on the continuation and initiation of any legal proceedings against a corporate debtor, which is Green Lighting. So, your ladyship, the first submission is that in light of that moratorium, these proceedings at this stage should have been stayed and this summons could not have been issued. Technically, your ladyship, the summons have been issued in the name of the RP, the resolution professional. Now, your ladyship, the resolution professional of a company only comes into play once the company goes into CIR. The allegations in the before the learned trial, these allegations pertain back to 2021, prior to the insolvency process of this company. However, today, by summoning me, the learned trial court has, the ladyship, erred on the law of the insolvency code and has essentially, your ladyship, created a situation where the RP, who's based in Uttarakhand, he stands to suffer, he stands to be harassed inadvertently on account of these situations, which is why we are before you, ladyship.
Who is the order issuing summons?
That's your ladyship. The order for issuing summons is at page 427 itself.
No, that is a summons.
Yes.
Not the order.
The ladyship will see 429. Maybe.
Yes.
Yes. The ladyship will see CR put up. Counsel is present. As regards non-appearance of the complainant, an application has been filed. Your ladyship will have the paragraph starting learned counsel for the complainant submits before this honorable court that while order dated so and so passed by the honorable court in IA number 213 of 23 This honorable court had directed the complainant to take steps and issue summons to the accused number one company represented by Sri Amar Gopal Gambhir IR. However, the same could not be taken as the said representative of the accused number one company has been replaced by one Sri Rajiv by order dated 10th of January 2023, passed by the Honorable NCLT. It is therefore prayed that NO be passed, directing the complainant to take steps for the issuance of summons to the replaced representative, Sri Rajiv. Now, your leadership, there's also another aspect that I wish to point out in this case. Your leadership will see that there are two accused persons in this in these proceedings. The first accused person is the company, essentially, and the second accused is the director of the company who was at the helm of the offense at the time of the alleged commission of offense. Your leadership, in July of 2023, this honorable court has already closed the proceedings against accused number two, the same proceedings. The only reason why proceedings were not closed against the company was because the company was not a party to those proceedings. If your leadership will have page 334 in the petition, the order dated 20th of July 2023 by this honorable court has been passed. 334, your leadership, the order starts.
Yes.
Your leadership will directly come to 393 for the relevant portion.
So you're praying for interim stay?
I'm praying for a stay on the summons.
All right. So this is the 393, which paragraph?
Yes, leadership, para 78 and 79 are the operative portion. In view of the above discussion and conclusion and also law enunciated by the Honorable Supreme Court, this court is of the considered view that the complaint case, being CR case so-and-so under section 406, 420 IPC pending before CJM Dimapur, Nagaland, and its consequential proceedings in taking cognizance and the summon dated 9/3/2022 under section 406, 420 IPC against the petitioner is nothing but an attempt to impart a criminal color to a civil dispute. Accordingly, the CR case is the petitioner pending before the CJM Dimapur and its sequential proceedings in taking cognizance and the summon dated so-and-so is hereby set aside and quashed. In fairness, your leadership, I must point out this order has been challenged before the Honorable Supreme Court. However, there is no stay as on date.
Okay. So he is the owner of this criminal revision number 4 of 23. So this petitioner is the owner of the company.
Petitioner is the erstwhile director of the company leadership, the director who was at the helm of the affairs before the insolvency proceeding.
And now it is the company before us.
Now it is the company. Now your leadership, RP of the company is before. The resolution professional appointed by the NCLT is before your leadership.
Goro Mamik is the director of the company and the accused number 2.
Yes, sir.
Rajiv Bhatnagar is the resolution professional of MSUM Green Lighting. So
yes, your leadership. UN Green Lighting is the accused number 1.
Is accused number 1. Yes, what do you have to say? Other side. You have already responded?
No, Lordship. I am resolution professional, Rajiv Bhatnagar.
Petitioner in person.
Okay. The state of motion. So who is for the state?
Uttarakhand, Lordship.
Anybody represent the state? No.
Leadership, I believe the state was served within advance copy is what I've been informed.
Just a moment. Where is the FIR against you? Where is a criminal case has been initiated against you, isn't it? Summons?
Yes, Your Ladyship. The criminal case starts at 288.
Page 288.
Yes.
Okay, I'll pass an order later, or maybe I'll take some time to pass an order. You're insisting on stay, then I'll have to pass an order later. I'll have to go through the entire file.
Lordship.
So if you do
Like-
not insist on stay, then we'll issue notice to the other side and then we can proceed.
No, Your Ladyship, we will insist on the stay of the summons.
So you're insisting on stay. So we have the FIR, the complaint here, and then the petitioner is the accused number 1. The case against the accused number 1 has been quashed.
Against the accused number 2 has been quashed.
Accused number 2 has been quashed. On that ground, you're insisting on stay.
That is one ground, Your Ladyship. Second ground is the moratorium under section 14 of the Insolvency and
Just a
Bankruptcy
moment, just a
Code.
moment. Moratorium under section
14 of
14,
I.
Your Ladyship, 1/4 of the Insolvency and Bankruptcy Code,
Hmm.
which is currently applicable on the accused number 1 company.
14 of D. It is in the petition. This ground is in the petition.
It is, the ground is in the petition. And another ground, Your Ladyship, is that the petitioner before Your Ladyship and the summoned person is the resolution professional of the company, who had nothing to do with the company at the time of alleged commission of the offense. So therefore, even if it is assumed that an offense has been committed, even in that case, the person before Your Ladyship today cannot be summoned in this case, being a court-appointed officer.
Anything else on these grounds?
May I
Just-
intervene,
just one-
Rajiv?
Yes, Mr. Anthony.
Yeah, my lords, with your kind permission, I am the additional counsel assisting Mr. Goyal here.
Yes.
With your kind permission, may I list some grounds before my lords?
Yes.
My lords, first of all, I would like to mention here that the position of a resolution professional is different from the position of a director. There is a new law, Insolvency and Bankruptcy Code 2016, in which when a company goes in insolvency, the relevant order is Annexure P1. A resolution professional is appointed by the court NCLT, National Company Law Tribunal. Since the matter was before the NCLT Delhi, so P1 and P2 are the relevant orders regarding the appointment of a resolution professional. And these orders talk about the moratorium also, my lords.
All right.
Section 14 of IBC. Secondly, my lords, since the offense alleged in the complaint, which is my lord P9, they are prior to the invocation of CIRP. Invocation of CIRP is P1, my lords. The alleged offense are prior to the CIRP, Corporate Insolvency Resolution Process, my lords. And the present petitioner before my lords has nothing to do with that offense. And he is merely working on the official duty under the provisions of IBBI and appointed by NCLT court, my lords, as a administrator in other terms. The third point, my lords, to be noted here is the very much complaint which is in question, against which the summons have been issued to the present petitioner. It has been very much quashed by this honorable court only, my lords.
Yes.
The High Court order is annexed very much here.
Yes. Yes.
P14, my lord. And with very much observations, my lord, that
So,
the dispute of a... Sorry, my lord.
He has given me the page number P14.
Yes, my lord.
At page 334 to 393.
Yes, my lords. I would like to add, my lords.
And what about P1? P1, what is the page
P1,
number?
yes, my lord. My lord, I would like to mention here that a new
One
law
is
was
at page
elected.
35.
Huh? Which is the page number?
Even at page 35, 35 it starts.
Yes, my lords.
What is the page number?
2 is 52.
52, my lords. P2 is 52, wide which the present petitioner was appointed by the honorable court to work as a resolution professional of the company, as a administrator of the company, as a court officer, as a representative of the court to handle the affairs of the company for the timing, to manage the affairs and to bring the company to the resolution.
Yes, and you were submitting about a new law?
Yes, my lord. This is a Insolvency and Bankruptcy Code 2016, my lords, in which the present petitioner has been appointed as a resolution professional, wide P2, my lord, Annexure P2. And this law, my lords, have overriding effect under section 238, my lords. This act will prevail over all the other legislations for the time being in force. So the representative, that is resolution professional, has immunities under a relevant section, that is 14 of IBC, 233 of IBC and 238, my lords, may kindly note.
RP, resolution professionals immunities under section?
Under section 14, my lord.
And?
Under section 233.
Yes.
Read with section 238, that is saying about the overriding effect of the act.
I think
it is a special legislation, my lord.
I think it is sufficient because we have a judgment also.
Yes, my lords. Moreover, my lords, I would like to add, if my lords may grant me permission, my lords, the questioning by this very much honorable High Court has observed that the allegations in the complaint are purely of the commercial nature.
Yes,
and there is a well settled judgments of the honorable Supreme Court various times that a commercial dispute cannot be brought under the IPC and all that.
All right, that I have noticed in the last two paragraphs.
And if my lord may give me 1 more minute, my lords.
Yes, yes.
Yes, my lords. My lords, since the complainant here in the complaint has very much challenged the High Court quashing order before Supreme Court also in SLP, my lord. SLP is mentioned here in the petition, and the Honorable Court has not, Apex Court has not granted any stay of the quashing. Quashing is still surviving. And quashing is very much regarding the contents of the complaint, rather commercial nature dispute. And one more fact I want to bring to light of this Honorable Court is, since the IBC, this CIRP process, when it is invoked in a particular company, presently it has been invoked by you for Greens through P1, Annexure P1 court order. After the company, once the company is into CIRP process, all the commercial settlements, whether debit or credit, give and take, any kind of liabilities, assets have to be settled by the NCLT. No other court can interfere, and there is a moratorium under Section 14.
Yes, yes.
There is a moratorium against all the cases, and all the cases will get stayed there and then only on the date of invocation of CIRP period.
All right.
And if my lords wish, we can supply the copy of updated insolvency and bankruptcy code also right now through email, my lords.
Yes.
And any other relevant provisions to assist the my lord. Because my lord, one more I want to bring in addition to something. Since the petitioner is residing in an outside state of Nagaland, he is in Uttarakhand. So the honorable magistrate has not even followed the process of 202 CRPC.
All right.
Yes, my lord. This is a technical point. Rather, we are not relying much upon that. We are majorly relying upon the role of the resolution professional here. He is a bona fide professional working under the directions of NCLT, has nothing to do with the offense, and is protected by all the provisions of IBC and the settled laws.
All right, then you can send through email the updated, the up-to-date IBC.
And my lord, before passing the order, we can again assist the my lord before passing the order if there is any query, my lords.
All right. Okay. So you
Your
can.
Ladyship, just one request. As an argument, your Ladyship will consider this. In the event your Ladyship take a view that a stay is not in order in this case, at least your Ladyship will allow the RP to appear through VC before the learned trial court, because the hearing is coming up on the 6th of March. And your Ladyship will appreciate that the RP has to appear from Uttarakhand. So that would be an additional prayer in the event your Ladyship is not inclined towards stay. And may I request the court master to please provide an email ID where we can supply the copy of it.
Please give him the email ID so that he can give me the up-to-date IBC.
My lords, I want to add to Mr. Goel's submission, if my lords may kindly permit me.
Yes, yes.
Yeah, my lords, since the complainant went to Honorable Supreme Court in appeal against the order of this Honorable Court, and simultaneously he has filed an application before CJM, he is using the double process, my lords, parallel process, and concealing the facts before the CJM Dimapur that he has filed an appeal before Supreme Court also. He has concealed this very much fact before the CJM Dimapur also, my lords. So he has misused the process of law, my lord. The complainant has misused the process of law. My lord may kindly note this point of also, my lords. Because he could have taken this plea before Honorable Supreme Court in SLP that I want the complaint to sustain against the company otherwise. So he has kept in dark both the courts, Honorable Supreme Court and Honorable CJM Court Dimapur. He has not disclosed to CJM Dimapur that he has went in a SLP before Supreme Court. My lords, am I audible?
Yes, yes.
Yes, my lord. And moreover, my lords, the petitioner cannot be categorized in the category of an accused because he never had any role. He is an official person appointed by NCLT court, my lords. So company was only a pro forma party in the complaint, my lords. The main allegations were against the accused. Even if my lords may take the opinion that the allegations survive, the allegations survive only against the accused, and that too quashed by the honorable court, and that too appealed in Supreme Court, my lords. So the CJM could not have intervened or took the cognizance against the petitioner when the complainant is already before the Honorable Supreme Court, my lords. So there is a contempt of the Honorable Apex Court also, my lord, and contempt of this Honorable Court also, my lord. Am I audible, my lords?
Yes.
Yes, my lords. So that way, my lords, the complainant is misusing the process of law. There is a unnecessary harassment to the petitioner, my lord.
All right.
Yes, my lord.
Let's
They can send it here. Kohima @gmail.com or VCTUC.
may it please your lordships.
Just a moment. You just take down the email address.
Bench section .kohima@gmail.com.
Kindly, sir, can you read?
Bench section.kohima@gmail.com.
Not clear, sir. Kindly repeat.
Bench section.
Read out the alphabet.
B for Bombay, E for England, N for native, C for Calcutta, H for horse,
Section SECT.
S for sparrow, E for English,
Yes.
CTION.
CTION, C for Calcutta, T for town, I for India, O for onion, N for nation.
Kohima.
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 Yes. Yes.
@gmail.com.
Gmail.com. And my lords, to add means again a humble request, my lords, if before passing, my lords may again hear to us, my lords.
Millards, one submission. My learned friend has argued, Millards. I'm sorry, I was held up in.
Just a moment. Just a moment. So this the order which was quashed by this court. So he preferred an appeal. So this this case was launched separately, or
Yes, no, my lords, in appeal before Honorable Supreme Court.
No, this
what happened? Yes, my lords, I will brief. What happened after going into the appeal before Supreme Court? The complainant filed an interim application before CJM Court, Dimapur, that the High Court has only quashed the complaint against accused number 2. So kindly issue summons to the company through resolution professional. And that is why the impugned order has been issued for issuing summons, my lords. He has concealed the very much fact that he has gone to the Supreme Court.
Where is the petition? Have you given a copy of the petition, interim application, before the?
Yes, my lords. That is Mr. Goyal, kindly. Yeah, that is, I think, my lord, it is page number 288, my lords.
Page number 288, okay. All right. Yes. Yes.
Millards, I make just 2 submissions. I also beg to appear for petition. My learned friend has argued, Millards. I was held up in Supreme Court. 2 short submission, Millards, I would like to place for Lordship's consideration in addition to what my learned friend has argued. If Lordships will graciously be pleased to look at the order passed by this Honorable Court, whereby the summons against directors were quashed. if my lords will look at para 68 of the coordinate court's order, my lords, that is 68 onwards. In fact, that's a finding of my lord's court. It records that the fundamental dispute between the de facto complainant and the directors of my client, means the directors of the company under CIRP, is basically of a civil nature. And my lords, that finding is a finding of a fact. The whole complaint revolves around the act of the directors who has succeeded before this court, that he is the one who has committed criminal breach of trust. So the allegation against company was non-existent.
Yes. So there is something wrong with the connection.
Yes, I think he's got this. Mr. Oja is a advocate on record at Supreme Court of India, my lords. So there may be some disruptions, I think. So my lord may ask us any question, my lords.
So I think I'm satisfied by your submissions. Let me see if I have any questions, then I'll ask you later.
My lords, if my lords can, the honorable court master can have our mobile numbers also to contact us again, my lords.
All right.
So my lords, if those directors, my lords, I was making a point that if those directors, by operation of my lord's decisions, have bypassed the criminal proceedings, they stand discharged from all those. How can company be unilaterally proceeded against? What purpose this trial will essentially beget? Secondly, as my learned friend has indicated, my lords, as lordships have been exercising jurisdiction under company court, when my lords used to appoint an official liquidator to hold the company, the same is the position, identical is the position which a resolution professional or an interim resolution professional perform. He is a person who is a professional who is independent from the company. He has no role as such to be performed. So here in this case, by calling him again during the process of a trial will further no useful purpose, my lords. So therefore, as an interim, my lords, we would be beseeching my lords' indulgence to at least stay these proceedings so that till my lords decide it finally, at least he is not.
All right, then. I'll pass an order later. So this again went off.
Kindly, my lords. If my lords may direct, we can provide our mobile numbers, my lord.
Yes. You know, Doctor?
My number is 99922 54304. Mr. Rajiv Bhatnagar, who is resolution professional, his number is 99174.
No, the party's number is not required.
Okay.
That
Okay,
number
my lord.
The party's number is not required. Despite the fact that he's appointed from the court, it's okay. Your number will suffice.
Okay, my lord. Just to the my lords. Anything else we can assist to the my lords right now, my lords?
Or I may pass the order today itself.
Great, my lords. We feel obliged, my lords. Thank you.
Obliged, Lordship.
For motion, item numbers 22 and 23.
Please, Your Honor. Your Honor, the respondent petitioner.
Just a moment. Albert.
Yeah.
I've noted down the arguments on the papers, on this paper side. Yeah, on this side. Yes.
Your Lordship, this is to do with the check bonds. The respondent petitioner had filed an joint affidavit before this honorable court and had given an undertaking before this court via order dated 14/12/2022, whereby he had given a check to the applicant respondent with a condition that after every 20 days that he will be allowed to withdraw the money. But here the check has been bounced and the bank has returned the check to the applicant responding, saying like there is insufficient funds insufficient.
So
And-
this was the order dated 14/12/23.
Yes, Your Honor.
Through this order that the other party has agreed.
Yes, Your Honor, the party personally appeared before this court
Mm.
and they have given an undertaking before this court saying that they will comply with this order. But 2 times the check have already been bounced and also notice has been issued, which the applicant, the respondent petitioner has also received. And till date, there is no response as such. And this is a pure case where the respondent petitioner had it is a contempt of this honorable court and also a perjury because they have given an undertaking, a file an affidavit before this honorable court. And Your Lordship, till date, we have not received any payment and there's no communication with the respondent petitioner, Your Lordship.
So today they are appearing. Yes, what do you have to say? This is then you have submitted another application.
And this honorable court has given.
And this was registered as I.
Yes, Your Honor, this honorable court has given us the liberty by order dated 14/12/2023, stating that the court gives the liberty to the complainant to approach this court by filing application if any of the check is dishonored. And therefore, we are praying before this honorable court, that our check has been dishonored and therefore we agree.
May I please, Your Lordship? Lordship, as per the material placed on record, it is evident, it is clear. However, Lordship, I have a humble submission. After receiving the said application and after passing of the said judge order by this honorable Lordship, the present applicant, opposite party as well as the person who's for this affidavit has placed the issue before the board of director. However, Lordship, due to some difficulty, the board of directors could not sit for the meeting so as to issue the necessary orders with regard to release of the pending liabilities towards the present applicant. So Lordship, at this stage, I only have a humble prayer that this board may give another week time.
See, as soon as the check is bounced, so again, another case starts against the petitioner.
Yes, Your Honor.
So within the specified period of time, you will have to launch another case against the petitioner.
Yes, Your Honor. We had
But
already-
if I give you week's time, if I give you
Lordship,
a
in
week's
that
time,
case,
then
as
the
per the
limitation
provision-
period will be over.
45 days limitation period has already.
It will
elapsed.
be
In case
over.
of the- in case
If I
of
give
the-
you a week's time, when has the check bounced?
It was on 10th of January 2024, as per the records, Lordship.
So
As
then
per the provision,
notice
there
has to be,
45
so
days.
notice has to be issued within 1 month. Within 1 month, the notice has to be issued
30
and
days,
then you have
30
to
days.
reply.
30
Yeah.
days.
So
inclusive
45
leave
days,
notice,
total
15
45 days we have at hand. So if I give you 1 week's time, then I think the period of limitation will be over by then.
Your Lordship, there's like the first check was bounced on 20/12/2023, second was on 10/1/2024. And thereafter, after the check was bounced, we had already issued notice to the respondent here, which as we are already next year, Your Honor, Your Lordship. And next
So
year-
this order was on 14/12/23. So the
Yes,
check
Your
was issued and then when you presented the check, the check was dishonored on which date? 21.
2023. the
After
first
6
check.
days.
After 6 days.
Then you have already issued notice to the
And we have-
accused.
Yes, Your Lordship.
And the second time again, the check was presented.
The check was presented on 10th January 2024. That was also returned due to insufficient fund. And
On which date?
On 10th January 2024.
Same day it was returned.
Same date it was returned. And your lordship, thereafter, we have issued a legal notice to the respondent petitioner on the 23rd January.
Have they received the notice?
They have already received the notice. It's already delivered.
And have they given any response? No.
No, your lordship.
So I'll give only 1 week's time, so that within
Your
the
Honor,
period.
this is just an excuse because they have been doing this from the time of the beginning the case was filed. And in spite of this court, this is.
What is the amount? What is the amount?
The total amount is, your lordship, 51 lakhs, 8,800.
Lordship, my humble prayers, considering the difficulty involved at this present stage. Just 1 week time may be given to the present opposite party, Lordship, so as to fulfill the agreement as well as the liabilities.
Lordship, that is just the excuse that they have been making from the beginning, and they have been saying that they will make the payment, they will make the payment in spite of giving an undertaking before this honorable court, yet they have not complied with the order of this court, and in spite of giving them 1 week time, the honor, like, still, I don't think the.
So for purchasing sand,
for a machinery.
A stone crusher.
Stone crusher,
Yes,
purchasing
we
stone
sell
crusher.
machines, yes, we sell machines.
So, you sell machines.
We sell them, we sell, and they are the purchaser. So there was a business transaction between the present applicant and myself.
So you sold a machine.
We couldn't provide the machine because of the
Oh, sir,
pandemic.
okay, you couldn't provide the machine and so you had returned the money.
Yes, now they are asking the money and we are willing to pay that also.
So you were convicted?
No, Lordship.
You were not convicted?
Your Honor, this matter, the one which is pending in the Kifi court has been stayed because of the.
It has not been stayed. This court has never stayed the proceeding down here. This court has only quashed the NPWT, which was issued against the present.
NBWA. This court has quashed the NBWA issued against you.
Not quashed, but it was stayed.
It was stayed.
Yes.
Okay.
There is civil and criminal proceeding before the law, before the below court, Lordship, at Kifri.
NBWA was issued against you and that has been stayed.
That is based in this present.
So the proceeding is stayed. The proceeding is proceeding.
But the civil case is still proceeding.
Proceeding, and the criminal case is proceeding or it has been stayed?
To my knowledge, Lordship, civil proceeding is not stayed.
So I'm not asking about the civil proceeding, the criminal case?
Criminal case, Lordship, this was in order to the extent that the NPW issued against the present criminal review.
So this case is pending at which
petition has been
stage?
stayed.
This criminal case is pending at which stage?
Your Lordship, this letter has been stayed by the order of this court dated. Your Lordship, even this order dated 14/12/2023, this honorable court has state, in the meantime, the proceeding before, in para 6, in the meantime, the proceeding before the court of the Chief Judicial Magistrate, P.P. Nagle, in connection with criminal complaint case number 1 of 2022, shall remain state.
I beg your pardon, Lordship. The criminal proceeding has been stayed by the recent order of this Honorable Court, Lordship. I may be corrected.
So if time is not granted, in what manner do you want this petition to be disposed? I criminal?
His honorable court, but if your lordship may first issue notice or warrant against the respondent as to why the order dated 14/12/24 has not been complied with the lordship.
But he's already here and he's making his submission.
Lordship, just 1 week.
So why are you not able to pay the money? Board of directors, you said something about the board of directors.
Lordship, I'm just an agent. There's board of directors who sits above me, so they have to make a decision.
The check was issued by, the lordship, the check was issued by the company themselves. And they had sent a representative and authorized person to appear before this honorable court. And that person had already given, on behalf of the company, given an undertaking before this honorable court that they will honor the check.
So 1 week time for what purpose? You want 1 week time for what purpose?
So as to see that the emergency meeting is conducted and the board of directors issue some notice or a decision may be taken so as to fulfill this settlement.
Your lordship, since there is 3 more check remaining.
I don't see any positive, there'll be any positive response from your board. Again, the same issue will crop up. Time after time, you're taking time, but you're not paying the money. As promised, as agreed.
Lordship, in that case, this matter may be fixed on first. I'll take necessary instruction and this board may pass
So then you'll turn into a contender if this order is not followed.
Your Lordship, we still have two more check with us, and which is due on 21st of February, which we have not withdrawn yet. And another one is on 13 March 2024.
So if the check bounces again, then you'll turn out to be a contender. So what do you suggest? The other side, should I give him time or should I reject his time and?
Your Lordship, this is a case where they just try to use delay tactics, and they've been assuring the petitioner for this past 4 years now almost, and they have always been assuring, but till date they have not complied with, and therefore, Your Lordship, even if time is granted, they're gonna appear before this court and pray for time again. And here, I think the order is very clear itself, Your Lordship. If the court may take the necessary steps for the contempt of the court, will be much obliged.
So yeah, on 23rd, there was a prayer for adjournment. That prayer for adjournment came from which side? From your side?
From our side.
From your side.
Because I was not.
Okay.
Present.
Oh, you were not present. Okay. So then one chance, I think, could be granted. Last chance.
Last chance, that's last chance.
But please, may you must make sure that there's sufficient money to honor the check. Otherwise, thereafter you will turn into contender.
Oh, sure.
All right. And finally, cost will be imposed upon you then.
Fixed date, Lordship.
Yes, of course, fixed date. Hard Miss Pakindri Sapo.
No, Esther Kelly.
Oh, it's 22 or 21? 21. Okay, your name is not reflected. You are for the.
Your Lordship, my name may be reflected in the cost list.
Oh. You are for the. You are for the petitioner.
For the petitioner.
For the applicant. Her Miss Esther I.A., learned counsel for the applicant who has filed this application. in connection with order dated 14/12/2023, passed in criminal division number 3 of 2023. The revision petition was initiated against the respondents. As the checks issued, earlier two checks, as the checks issued by the two checks, no, for amount of rupees. What was the earlier?
Your lordship, the first check is amounting to rupees 10 lakhs.
Annexure 2
10 lakhs.
of the IA.
And the second check was also for an amount of 10 lakhs.
For amount of rupees 10 lakhs each were disordered by the bank. Thereafter, when both the parties appeared, both the parties entered into an agreement, and the order dated 14/12/2023 of this court in criminal division number 3 of 2023 reflects that both the parties have amicably resolved the dispute. And the petitioner and the respondent have come to an amicable settlement that the opposite party, respondents will pay an amount of rupees 51,08,800, rupees 51,08,800 to the present petitioner stroke applicant. It is in the IA only, huh?
Yes.
Again, two checks were issued. Again, two checks. Both the checks have bounced. Again, in furtherance of the settlement, two checks were issued by the respondent stroke opposite party, being check numbered. Take down the numbers, huh? 982 within inverted commas, 982,992 hyphen 313002091 hyphen 000219 hyphen 29 dated 20/12/2023 and check number again within inverted commas 982,993 hyphen 313002091 000219 hyphen 29 dated 10/1/2024 were issued by the respondent. This is the company.
Yes, ma'am.
Respondent company, but both these checks were dishonored. And notices have already been issued by the applicants to the respondents. The learned counsel for the respondent, Mr. What is your name?
Ali Bowski.
So and so has submitted that the respondents have to that the respondents required for a decision between the board of directors, and they have and the respondents have pledged to honor the checks without a decision between the board of directors no decision can be taken for payment of the aforementioned amount and to honor the checks. Full stop. Two checks are yet to be presented before the bank. Three, it is also submitted at the bar that 3 checks are yet to be presented before the bank. Considering the submissions at the bar with circumspection, a last opportunity is afforded to the respondents to honor the checks.
Lordship, this check, one check which is already overdue, which was supposed to be drawn on 31st January 2024, the respondent applicant has not.
Honor the 2 remaining checks.
Yes.
Honor the 2 remaining checks in compliance of the order of this court dated 14/12/2023 in connection with criminal revision number 3 of 2023. List the matter on. So we did, before that you honor the checks. List the matter on 1 week's time. Yes, not later than 4th March.
Yes. Much obliged.
For admission, item number 5.
Yes.
Yes, your lordship. I'd like to take your lordship to annexure 1, page 6 of the affidavit in opposition filed by the respondent number 1. I'm representing the respondent number 1 here. Lordship, this is the scheme office memorandum formulated by the state government for regularization of work charge and casual employees, your lordship. And the basis of this office memorandum, the petitioner was, a direction was given to the state respondent, particularly me, to regularize the service of the petitioner, your lordship. May I read, your lordship? Government of Nagaland Personal and Administrative Reforms Department, Administrative Reforms Branch, dated Kohima, the 17th March 2015. Office memorandum subject: scheme for regularization and absorption of work charge in casual employees and revision of pay stroke wages. On due consideration of the report of work.
Which page are you reading? That affidavit. Para number 6.
Yes, page number 6, your lordship.
Page number 6.
Page number 6. Annexure 1, your lordship.
Yes, yes. Yes, yes.
Yes, it is given as office memorandum.
Yes, office
Yes.
memorandum.
Scheme for regularization in absorption of work charge and casual employees and revision of pay stroke wages. On due consideration of the report of work charge and casual employees commission, and in compliance with the judgment and order of the Honorable High Court, the Governor of Nagaland is placed to introduce the following scheme for regularization in absorption of work charge and casual employees and revision of pay and wages subject to the conditions indicated hereunder. Number 1, regularization in service. Number Roman 1, all existing work charge and casual employees of various departments who are enjoying scale-up pay and who have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of their posts into regular ones, personal to them, subject to fulfillment of condition as indicated below. Number A, the incumbent concerned in her service rendered as worker casual employee have to be duly verified and found genuine by the district level verification committee constituted by the government. Your lordship, my issue is this. Direction was given by this Honorable High Court on 10/11/2022. Now, in order to regularize, in order to comply with the direction of the court, the petitioner must be verified by the district level verification board. Now, in the district level verification board, deputy commissioner is the chairman. This college in which the petitioner was serving was Fazal College located in Mokokchung district. So once the district level verification procedure is like that, total formality, has verified all the department, the incumbents who are to be regularized, completed 30 years. Then it has to be sent to the concerned department. And from the concerned department, it has to go to the government. From government, it has to do with the Department of Personnel and Administrative Reforms. And thereafter, to the cabinet, state cabinet. So the total procedure is long enough, very long enough. Number two point. Since it's a regular, it's going to be regularized. There has to be a sanction, regular sanction board to accommodate the petitioner. So this were the two obstacles, Your Lordship. So we have initiated, right after receipt of the judgment and order passed by this honorable court, we have initiated, but it was found that the petitioner was not verified. His name was not verified by the district level verification board. So because of that obstacle, it was his regularization could not be initiated because number one condition is it has to be verified by the district level verification board, which is normally the deputy commissioner of the district. So that is the thing. That is the thing.
So what is
in the order passed by the Honorable High Court, the Lordship will find in the page 28.
Page
28 of the contempt petition.
Page 28 of the contempt petition.
Yes, the operating para. The operating para of the judgment and order passed by the Honorable Court.
Well, addition, appointed portion is from page 27, not in 27, it will be from the last second part.
Page 27 of the petition, okay.
Yeah, why this is written because this specifies about the OM, what the condition is.
Page 27, yes.
Yes, we have read the operating para, Your Lordship, page 28.
Page 28, yes.
Page 28, last para.
Yes.
Since the contentions raised by the petitioner have not been disputed by the learned state council, either on facts or on law, I propose to dispose of this petition at the stage of motion, hearing itself with the direction that the respondent authorities to regularize the service of the petitioner in terms of the OM dated 7/3/2015. The OM just now I read out, Your Lordship, issued by the Personnel and Administrative Reforms Department by number such and such, by following the procedure in the time schedule prescribed in the OM. So, Your Lordship, that is the only thing. That is the only thing. We are taking the initiative so that the
So
name
what
of the
is the-
petitioner is included in the.
What is
state
the
verification
cure?
report.
What is the cure now? We need the cure now. So is he a contempt now? We need a cure now.
Yes,
So what is the cure? They are still processing, he is saying.
just in verbal, nothing written that they are processing. One can say that I'm processing your matter, but something has to be written to say that, and then to.
So what is the cure? That you must, I think you must go back to the district level committee.
Yes, it has to be verified, but it is the duty, responsibility to place it before the district verification board. These honorable court by the order has directed the state responsibilities.
Yes,
Has
yes.
to regularize my service as.
So then you adopt the procedures, what is required? You go back to the district level
Your
committee.
Lordship.
My ladyship, just for you, I will just refer to the OM once again. OM, which my learned friend has just.
Just read out, yes.
Yes.
What is the OM?
In the contempt petition, it's page number 14. 14
Page number 14, yes.
Yes. My learned friend, he has referred to the first paragraph. Now, I mean, take your ladyship to page number 15 of my in the petition.
Page number 15, yes.
The operating portion is Roman number 2, H, clause H, Roman 2. My case is covered by this. In respect of those who church and casual implies in scale patient who have completed or will complete 30 years of continuous service after 1/1/2015, a case for regularization will be taken up subsequently in 2 pages, as on 1st July and 1st January every year. It says 1st July and 1st January every year. The procedures and terms and conditions will be the same as laid down in this poem. It says it has to be 2 pages. First page will be 1st of January, the second page will be in the month of 1st of July every year. And this honorable court has passed the order in the District 50 of 2022 on 10/11/2022. 10/11/2022. Now.
10/11/22.
So. So, for consideration of my case, they have to place my case on 1st January, which resulted after passing the order. Because the order is November.
So this year it was not taken up.
January was not. I waited for August also, July also. July also not. As with the order, it has been 2 pages. First page is in the 1st of January and 1st of July every year. Now,
1st January and 1st of July. So we have July is approaching.
No, the order was passed on
10/11/22.
So it's almost a year. 2 January has gone, July has also gone.
So
Now,
what to do now? Punish another contempt of court?
Yes, because they have not yet processed. They are just saying it's under process. 2 January has gone. After the order was passed.
1st January and 1st July.
Yes.
In
and
2
then
batches, 1st July and 1st January.
24 July.
So three opportunities have elapsed.
And then they are just saying that it's under process. At least they should have some documents placing my individual before the board for regulation of assets. That is the only issue. If they are processing, then something has to be.
Your Lordship, kindly appreciate, please appreciate this, the difficulty of the state also. Now, my friend, yes, I agree to that. 2 pages, 1 in July, 1 in January. But what we do is, what state normally do is, the initiatives are, the first manner is taken only after the verification is done by the district level verification board.
So then
that is
why initiatives are not taken? Please take initiatives.
That is the problem.
Place the matter before
That is the
the
problem.
district level committee.
That is the problem.
So who will take the initiative?
They will take it.
We will take the initiative. That is
So-
why we are taking the initiative to place the
So
petitioner. at
then
the
it has
district
to be
level
placed on
verification.
record then, because this, so then it has to be placed on record. So this case will be pending.
That is, yes, your Lordship, we are taking the initiative so that when the district level verification sits led by the deputy commissioner, will put her name.
So this
and I put
matter
it-
has not been admitted, we'll admit this matter then. We'll admit this matter. Because you have also agreed that you'll take up the matter before the district level committee.
Yes.
So we'll
It
admit
is,
this
it is
matter.
our duty, I admit. It is the duty of the state to place the name of the petitioner before the district level verification board. So when the district level verification board led by the deputy commissioner said, we will definitely place her name, place his name before the
No,
verification.
we'll
board.
admit this matter then. We'll admit it for hearing. So during hearing, if the matter is settled, then what do you think? What is your suggestion? So should we keep it pending at the stage of admission?
No, no, no. Lordship, give me 6 months time so that the process is done. Your Lordship, kindly appreciate the difficulty of the state also.
No, 6 months. July is not 6 months away. July is only 4 months away. March, April, May, June. Only 4 months away. July is only 4 months away, not 6 months away.
Lordship, the problem is that when will the district level verification will sit, we don't know. We don't know. in a sense that it depends on the number of the applicants. So sometimes any year they don't say.
So,
So that is the problem, your
so
lordship.
you see, this order of
So
this
can you
court is
appreciate-
already there. This order of this
Lordship,
court
may
is
please
already there.
appreciate.
Passed on 11, this order of the court was passed on 10/11/2022.
I admit, your lordship. I admit that, I admit that.
And
But,
3 opportunities have already elapsed. So this is the 4th opportunity. So this person, he's working or he's been retired. He's retired.
So
For
now,
pensionary benefits, is he getting pension? No. Or extraordinary pension? Is he getting extraordinary pension? No. Okay. So then. after
lordship,
giving so
allow
much
me
years
6 months time. So during the process, I think
6 months will be
it
too
will
long.
be hearing. Just because process, it takes time, as I explained before, your lordship. Process, it takes time.
If 6 months is given to them again. They say that.
No, lordship. We are taking the initiative.
And then they will say again, they will apply for the genuine.
No, first step, at least take the first step. First step, at least the first step, that the matter has to be placed. Initially, the first step is the district level committee. The matter has to be placed before the district level committee.
Your lordship, I have explained the position of the state in my affidavit, as your lordship is well aware.
I'll go through it once more.
Lordship, we please turn to para 3, page 2
Para 3, yes, please read.
of the affidavit filed by respondent number 1. May I read, your lordship, that in compliance of this honorable court order dated 10/11/2022 passed in WBC so and so, and in consonance with the OM 17 March 2015 scheme for regularization of work tax and casual employees. The answering deponent has taken initiative for regularization of the petitioner by following the procedure in the OM. However, it was found that the petitioner was not verified by the district level verification committee as per para 1 Roman 1A of the OM dated 17/03/2015. And as such, the regularization of petitioner could not be processed. That is the problem, your lordship. Processed to the Department of Personnel and Administrative Reform for approval by the government. Para 6, your lordship. Para 6, your lordship. That the answering deponent respectfully states that the answering deponent has the highest respect towards the majesty of this honorable court and shall not do any act or disobeying action that has effect of diminishing the prestige and authority of this honorable high court and thereby lower the estimation of this honorable high court in the minds of general public. The delay was caused by following the dictates of court procedures in the OM dated 17/3/2015. It was due to the unintentional situation and circumstance as narrated herein above that the delay has been caused in complying with the order and direction passed by this honorable high court. Lordship, that is the thing. After the verification has been done only, the process for sending in the first minute, one in January and one in July starts. My friend has misread the OM. After verification has been done to the district employee, only after the verification has been done, the sending to the government for approval in the first minute as mandated by the OM, and January and July comes into play, your lordship. That is the thing. Because the petitioner is a district employee. He was employed in the district, a college in the Mokpong district. So that is the thing. So, your lordship, my prayer is that I have the highest respect for the majesty of this court since we are initiating, as in when the district levels verification board said, led by the deputy commissioner, we will definitely put the name of the petitioner and according to the process for regular.
So in the month of July?
Yes.
In the month of July?
That is why. That is why we need at least 6 months time, your lordship.
July is only 4 months away.
And then there are 3 opportunities already left.
4 months will be too short, your lordship, to be very frank. Frankly, I appreciate the Please appreciate the difficulties of the state also, Your Worship.
Just a
Because this is a regularization, clear vacancy has to be there, a sanction post must be there. So all this sort of things are also there, but we'll take the initiative and allow me state responder 6 weeks,
So
6
after,
months.
after retirement, what kind of sanction post will be there?
Yes, this is personal to them.
He, a person is retired. So if he was not retired, then there has to be a sanction post, I agree. But after retirement, what kind of sanction post will suffice? So that will be, this is called this parallel, what is this called? Appointment. That, parallel appointment.
I understand.
And they can read petition.
I forgot the exact word. So I've not been doing service law for a long time, so I forgot the exact word.
And then, my lady, in the read petition, the respondents have admitted that I'm eligible to consider for regularization, and basing on your own submission, this honorable court has passed the order.
Just let me go through the paragraph once more.
My under petition.
So if you insist that this petition is disposed of, then you will also not get any relief. So let us give them some time.
Yes, madam. My suggestion is, let them give a short time, and then this petition will be kept pending, because if this is closed, again, and no matter the petition, I have to initially start.
So the relief comes if this case is kept pending.
So, see, since July is coming, they promised to give us some time. And then they are just saying that they are taking the initiative to consider my case. But just verbally, there is nothing on record. At least.
So what kind of,
based by
record you want that they are taking initiative?
My papers should be placed before the revision board or requesting the district level revision committee for consideration of my case. If it is not placed before them, then I don't think the district revision level committee will come ask whether it need the applicants for consideration. They will be placed before the board.
All right. Yes, heard. Learned Council, this is item number? 5. Heard Learned Council, Mr. L. Longkumar. L. Longkumar for the petitioner. Sri Subha Yapang and you are for the school.
It's a college.
College.
I'm representing Dr. Vishwakar, the Director Higher Education, Your Lordship.
Respondent number education. ED.
Respondent number 1.
Respondent number 1. Higher education. Allah, senior counsel. Mr.
Yes. Yes. More ancient.
More ancient for respondent number 1. And learned counsel, Mr. V. Jumom for the Jimomi for the respondent number 2. The learned counsel for the petitioner has submitted that the order was passed by a coordinated bench of this court in 11/12/2022 in connection with the 10/11/2022 in connection with WPC number 250/2022, directing the respondent authorities to regularize the service of the petitioner in terms of the OM dated 17/3/2015 issued by the P and AR, capital P and capital AR department by the order number AR -3/GEN -201/2009 by following the procedure and the time schedule prescribed in the OM. I have considered the submissions at the bar with circumspection. The learned counsel for the petitioner has submitted that the petitioners are liable, or that the respondents are liable under this contempt proceeding as since 11/10/2022. No steps have been taken for regularization of the present petitioner in compliance of the order of this court caption in connection with the case captioned above, in connection with WPC number 250/2022. The learned counsel for the respondents has submitted that initiatives have been already taken to comply the order of this court, to comply the aforementioned order, or to comply with the aforementioned order of this court. The learned counsel for the respondent has submitted for at least 6 months' time as 6 months' time, as the petitioner's name was not verified by the district level verification committee as per para 1 within bracket Roman 1 bracket close small a within bracket small a of the OM dated 17/3/2015. It is also submitted at the bar that according to the aforementioned OM, the case of the work charge employees has to be taken up on every 1st of July and 1st of January of each year. Full stop. The learned counsel for the petitioner has raised objections stating that since the order passed by the coordinate bench of this court no steps have been taken to regularize the services of the petitioner. After considering the submissions at the bar, I deem it proper to allow 5 months time to take up the petitioners to take up the matter of the petitioner in compliance of the order of this court dated 10/11/2022 in connection with WPC number 250/2022. 4 months time. 4 months time. No.
If only they comply, because now they have not yet complied, they have to comply.
considering the time allowed to the petitioner, without closing the contempt petition, I deem it proper to list the matter on after 4 months, after 4 months. And respondents can produce any document relating to the process undertaken by the respondents to regularize the services of the petitioner. So when any document will be produced, then next time we can close the petition.
I beg your apology, Your Lordship.
Yes, yes.
I would like to mention item 11, Your Lordship.
Yes.
I have taken the concern of the other side. I have taken the concern of my petitioner's counsel. That Your Lordship, this matter will come up after 3 weeks. I am representing the state here. I am yet to file the affidavit, obtain instructions and file affidavit.
Learned government advocate, Mr.
Moa Imchen.
Moa Imchen has, with the consent of the other side, has prayed for time to file affidavit.
Yes,
This is the matter after 3 weeks.
3 weeks, Your Lordship. Operation.
Mm.
For admission, item number 8.
Yes, Your Honor.
Mm.
The present is a very simple case, Your Honor, where the petitioners were seeking for appointment on compassionate ground on the basis of office memorandum, where a father died in service while serving as inspector under the Bureau of Legal Metrology and Consumer Protection. To make it short, Your Honor, may I take you to the affidavit in the posting filed by the state respondents, Your Honor. The state already printed the affidavit. Paragraph 4 and 5.
Paragraph 4.
Yes.
Please read.
May I read, Your Honor?
Paragraph 4 of the affidavit. Yes, please read, yes.
Paragraph 1, done with regard to the statements made in paragraph 6 of the writ petition, the answering deponent respectfully states that in consonance with the OM dated 17 September 2015 and the addendum dated 9 April 2019, revised completion appointment scheme for state government employees who take in harness, the department of the answering deponent is maintaining a winning list in chronological order as envisaged in the addendum.
So your name is at serial number 4
Yes, Lordship.
in the waiting list.
Yes,
So sometimes that serial number doesn't come also.
yes, and then where is it that?
It depends actually, it depends. The number of posts and then your seat turn. If you don't get the turn, you may not be appointed. So what to do now?
So in this Lordship, I put that disposal in line with the paragraph 5 of the determined position. To strictly consider the case as per the office memorandum. And then as per
I can
the-
dispose it off.
Yes,
Yes.
yes.
As per office memorandum, yes, who is appointed? So I can dispose it off at the to strictly comply with comply.
Yes.
Will his turn come? You never
It
know.
will come, yeah, but we can't give a time bomb.
At serial number 4. There has to be post also. There has to be post.
Yes.
And it is taken after every 3 what is the time gap? After every 3 years or after every 5 years? What is the time gap over here?
No, Your Honor, it depends on the vacancy created.
Vacancy created. And sometimes this office memorandum is superseded also. So when in supersession new memorandum comes up, then maybe there'll be another new type of consideration. So it depends, all right. So I'll dispose it off then. Heard Mr. So-and-so, learned counsel for the petitioner. So-and-so, the petitioner has filed this application under Article 226 of the Constitution of India for issuance of a writ in the nature of mandamus or certiorari or any other writ directing was rule issued earlier? No. No. The petitioners to strictly comply with the OM number, OM dated 17/9/2015 and at the addendum dated 9/4/2019 and provide appointment to the petitioner on compassionate ground. Heard Mr. So learned counsel for the government advocate.
Yes.
Government advocate for all the respondents.
Yes.
For the respondents, the respondents have submitted an affidavit in opposition. And white para number, which one?
4.5.
Para number 4 and 5, it has been admitted by the respondents that in consonance with the OM number, capital AR -8/8/78 dated 17/9/2015 and the addendum dated 9/4/2019 within inverted commas, bolded likhiba, revised compassionate appointment scheme for state government employees who died in harness, inverted commas close, the department of the answering deponent is maintaining a waiting list in the chronological order as envisaged in the addendum dated 9/4/2019, full stop. As per the waiting list for appointment on compassionate ground, the name of the petitioner stands at serial number 4, full stop. The petitioner is the son of the employee who died in harness in the year, son of the employee who died in harness in the year,
17/8/2021.
who died on 17/8/2021 while he was serving as
Inspector under the Department of Legal Metrology and
inspector under the Department of
Legal Metrology and Consumer Protection.
what metrology?
Legal Metrology.
Oh. Where is legal LEGL, legal metrology and consumer protection, Mon Nagaland. Huh? Mon, Mokokchung, Nagaland. Okay, sorry. Mokokchung, Nagaland. I have considered the submissions at the bar as the petitioner's name is at serial number 4, the respondents have submitted that endeavor will be made to provide appointment to the petitioner as soon as possible.
As and when.
As and when possible, considering the every endeavor will be made, full stop. Considering the submissions at the bar and considering the submission of the respondent, a direction is given to the respondent to provide appointment to the petitioner in compliance with the OM number. Once more, where is the OM number?
17/9/2015.
17?
9.
Oh, OM number AR-8/8/78, dated 17/9/2015. And as per and under the provisions of the addendum number 9/4/2019, as and when possible. Matter stands closed. Matter is closed. With the above observations, matter is closed.
For admission, item number 24.
This is a regular bail application for internship. Already the file is at page 10A.
10A.
10A, page 25.
Please read.
Yes. Complaint against Mr. Ajay Bahadur Singh. With due respect, I would like to bring before your kind authority the following few lines for your necessary action. One, that Mr. Ajay Bahadur Singh, proprietor of sanitary hardware stores, Dr. R.P. Road, Ganeshguri, Gauhati, Assam, having GST number so and so, mobile number so and so, have agreed to deliver products material that is TMT Riba within 10 to 15 days. As such, I have met payments totaling to rupees 23 lakhs 26,000 on different dates, that is 1 lakh on that 26 November 2022, rupees 21 lakhs 26,000 on dated 29 November 2022, and rupees 1 lakh on 14 December 2022. Number two, that despite of the payments being met, Mr. Ajay Bahadur Singh have not delivered even a single piece of TMT Riba, and he keeps on extending the date of delivery for the last over 3 months. Again, an amount of rupees 3,90,000 was paid for supply of tiles, which he intentionally supplied wrong quantity and wrong variety of tiles until that he is neglecting to correct the same. My lady, in this case, there are two contentions that can be seen from the FIR. The first is regarding the TNT rebar, supply of TNT rebar, and the second is the supply of tiles, which the alleged accused has supplied. And then the contention of the complainant is that the materials of the tiles is not up to what has demanded. Now, my lady, in this case, the alleged accused is behind bars since 11th of January 2024. As of date, today,
So have you received a case diary?
47 days. Yes.
How many days?
47 days.
40. Have you received a case diary of this case? Case diary?
Lordship.
What do you have to say?
Lordship, if you go.
Is booked under section 420.
420.
Have you applied for bail in the lower court?
Yes, it has been rejected. I have an access.
Then district court, district judge, sessions
Yes.
court?
Before the Honorable JMFC, and it has been rejected. So I felt.
Okay.
Lordship, I would like to place a case diary, Lordship. Lordship, this case diary, they have sent it through PDF, and it is some of the pages is not reachable. However, I would like to see.
So what is your objection?
Lordship, I would like to validly object to that, Lordship. Actually, Lordship is in this case, Lordship, accused. He is a habitual offender. Early case also, what happened was, Lordship, he was, the FIR was lodged before the suburban police station. Here, he was arrested. Before his arrest from the suburban Lordship, the alleged accused, he has been arrested by the Manipur police, Manipur state of Manipur. From there, the suburban police station, since the FIR has been lodged before the suburban, the matter was they arrested the accused from the Manipur police station, and then now several FIR has been lodged in different police station out here in Nagaland. Lordship. So, Lordship, as far as the petition, if we go by the bill application filed by the accused cousin, Lordship, the paragraph 2, 3, and 8, which is inconsistent with paragraph 4, 5, 6, and 7, Lordship. Here, Lordship, in paragraph 2, they have stated that the accused has not committed the offense as alleged for, and as such, he has been falsely implicated in the case. Number one. And secondly, what they have stated is that no bail application under section 439 of the Code of Criminal Procedure in respect of the concerned accused is pending or rejected by any court of superior court. Here they have clearly mentioned that there is no bail application or whatsoever that is pending, or neither it was rejected. However, Lordship, in this instant case also, Lordship, the bail was rejected in the lower court below. As Lordship is well aware, Lordship may kindly come to the page 40, Lordship. This in the Code of CJM first class,
Mm.
Dimapur Lordship.
Mm.
The operative paragraph is page 15, Lordship, the
Mm.
last paragraph, if I'm allowed to read.
Mm. Yes.
Starting from third paragraph, keeping in mind, Lordship.
Mm.
May I read, Lordship?
Yes, yes.
Keeping in mind the health condition of the accused as submitted before me today, the Superintendent of Jail Dimapur is directed to provide medical attention necessary to accused. Also, as the accused has submitted that he is under medication and has required medicine with him, the Superintendent of Jail may allow the accused to use the same medicine as deemed fit and proper. Copy to the Superintendent of Jail for information and compliance. Lordship may kindly come to what I would like to take my lordship attention to the prayer. The prayer portion, Lordship.
Mm.
Paragraph 12, Lordship.
Mm.
Page 7, paragraph 12.
Mm.
I'm allowed to read,
Mm.
Lordship. That a petitioner beg to submit that the offense is non-bailable, the accused above named, having no desire to evade the due process of law, shall face the trial to vindicate his innocence. His detention in custody will greatly harmful to him in the present circumstances. Here, here they have stated that it's a non-bailable offense, Lordship. But Lordship, as far as the present accused, he was booked under section 420. And 420 says that cheating and dishonestly inducing delivery of property. Whoever cheats and thereby dishonestly induce the person deceived to deliver any property to any person or to make, alter, or destroy the whole or any part of valuable security or anything which is signed or sealed and which is capable of being converted into a valuable security shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Classification of offense, Lordship. The classification of offense under section 420 is punishment, imprisonment for 7 years and fine cognizable, non-bailable, any magistrate compoundable, Lordship. So the prayer, Lordship, I have a Supreme Court rulings which says that here the present subsequent bail application, the present bail application filed before this honorable court under section 439 of CPC 1973. Lordship, there is no change of circumstances. There is no change of circumstances. Earlier also, before the lower court below, on the ground of health issues, they plead before the honorable court and it was rejected. Here also, Lordship, here the main prayer of the petitioner before your Lordship is on the ground on the health issue. So, Lordship, there is the cantina of judgment. In the Lordship, I would like to place that before the honorable court.
Subsequent bail.
Lordship.
No, no.
There is no change of circumstances.
Change of circumstances.
Lordship. If 2020 SSC online, Anand and others versus state of Kerala. Lordship may kindly come to operative third para, Lordship, if I may.
But it was dismissed by the High Court.
Lordship.
Yes, sir. This bail is not a subsequent bail application in the High Court.
Lordship. And secondly, Lordship, the same principle applies in.
But this was rejected by the additional session judge Tisu in this Humayun.
but the same principle applies for you. Here, in Humayun versus State of Kerala also, the operative portion will be part will be para 8 logic. This is the NDPS case, however, logic. Here, the bill was dismissed logic. On the same principle logic, no change of circumstances.
All right.
May I submit?
Mm.
My lady is pointed by the learned PP against the accused. There are three GRs. In 2 GR, he is on bail. And in this present GR, he is in custody. And so far as regarding the offense under 420, I would like to take your lordship attention to the ingredients, the essential ingredients under 420. Before going that, I would like to submit that this case is purely of civil nature. My lady.
So he is a habitual offender. How many cases are pending before him? 3 cases.
3. He is on bail in 2 years because he has settled the matter with the parties. It is in all these 2 cases also purely of business transaction, civil nature. He is a businessman. He has a store in Gauhati, permanent resident of Gauhati. He runs a hardware store.
The hardware store is in the guise of running a hardware store and trying to give the
That is just submission.
innocent people.
He is permanently settled in Gauhati. He runs it. He's a
So
proprietor.
you have again taken the plea that you are not well.
No, I'm not pressing on that. My lady, if you can come to
Earlier,
section-
before the judicial magistrate, you have taken the plea that you are not well.
Lordship.
And now again, you have taken the plea that you are not well.
I have said it, but then I'm not pressing on that. I am on merit.
But that is the same plea taken in this.
Initially,
present.
my bill was rejected. If my lady can kindly balance the order, the last para, the last, that is at page 13. The last line says, therefore, as the investigation is in progress, releasing accused at this stage may hamper investigation. Immediately. But then as of date, it is 47 days as of date. He has been in custody for 47 days. And I believe that 47 days is a long time for whatever investigation, what is required from the investigation authorities, they must have completed. And now considering that this is purely civil in nature, and then
No, that,
the offer
I'm
is,
not going to that merit because you have not come for
Yes,
watching of
yes.
FIR or anything like that.
yes,
So I'll grant him bail, let him go on bail.
Since
Local surety from Nagaland,
my,
local surety.
since the accused is a
Whoever will vouch for him will face the consequence. Local surety, I know he is a hardcore criminal.
Yes, lordship will.
But we can grant him bail. Investigation has also progressed. He is in the habit of doing all this. So it's, we cannot detain him as a preventive detention.
Lordship. But my submission may be recorded.
Yes.
But lordship, I just want to make one submission lordship. Since in the prayer of the petitioner applicant, there is no mystery such that there is a change of there is no change of circumstance.
Yeah, I'll record it.
Lord.
Had Mr. So-and-so learned counsel for the petitioner. Sri Anil Bahadur Singh, who has filed an application with prayer for bail of Sri Ajay Bahadur Singh, who is behind bars in connection with so-and-so PS case under so-and-so sections. The accused, Anil Bahadur Singh, Ajay Bahadur Singh, the accused Ajay Bahadur Singh is alleged to have committed an offense of cheating by the informant. The allegation against him is that he was to deliver TMT bars to the informant and receive payments from the informant of rupees 23,26,000 on different dates, but did not supply the TMT bars. Thereafter, again, on request of the accused, rupees 3,90,000 was paid for supply of TMT bars. Post up, the accused is alleged to have cheated the informant by not supplying the TMT bars. Post up, the hard Mr. You are the PP or additional PP?
PP.
Hard
Please
Mr.
remove.
Mr. So-and-so, learned public prosecutor for the state of Nagaland. The learned public prosecutor has submitted that the accused is a history cheater. Post up, he was arrested in connection with cases of similar nature. Post up, if enlarged on bail, the accused will not hesitate to commit similar offences and dupe the innocent citizens in the end and rob him of their dupe the innocent citizens and procure funds to supply TMT bars in a similar manner. Full stop. The learned PP has also submitted that no extra, what is your submission?
No change of
Or
circumstances.
that there was no change of circumstances. There is no change of circumstances to grant bail to the accused. Post up, earlier, by order dated 22/1/2024, the learned judicial magistrate first class, at Dimapur has rejected his bail application. Post up, in the earlier bail application, the accused took the plea that he was not well and treatment is required. And in the present application also, the accused has taken the same plea that he requires treatment. The next paragraph, per contra, the learned counsel for the accused accused as well as the petitioner has submitted that the accused cannot be detained as a preventive measure to be deterred from committing an offense, like deciding a case in a mini trial. Stop. I have considered the submissions at the bar with circumspection. The accused has been behind bars for 47 days. Stop. I have also scrutinized the CD. Stop. The statement of the informant has already been recorded. Stop. Investigation is progressing. It appears that further detention for progress of investigation may not be required in connection with this case. I have considered the submission that the accused is willing to cooperate with the investigation as well as with the trial. Considering all aspects, petition is allowed. The accused is enlarged on bail of rupees 30,000.
No, Lordship,
50.
The amount is.
Yeah, yes, too much, yes.
Lordship.
50,000. 50,000.
At least because it's almost 23 lakhs.
Oh, here you'll get local surety, 1 lakh. Who will come? One has to be a government employee, then only. 1,50,000 with two local share, 50,000 with two local sureties of like amount. 50,000 now, because you will need a service holder. Nobody will come forward.
Lordship.
And then it will be as good as not passing any bail order. So two local sureties of like amount to the satisfaction of the learned trial court under the condition that the accused shall not jump the bail, comma. Number two, the accused shall cooperate with the investigation, and if charge sheet is submitted, he shall cooperate with the trial. Number three, the accused shall not leave the country. Oh, no, he's not not required.
Should not leave that jurisdiction of.
No, he's from Gauhati, no. On failure of any of the bail conditions, the bail order shall stand cancelled. So this is not an economic offense to direct him to not leave the country. So this, I'm stacking it up, not leave the country. So this is an email CD. No point of sending it back.
For orders item number
I'll
12.
put the CD sent through email. And nobody's here for orders.
For orders item number 12. What is it?
So we'll see the office note and pass the order. Nothing in the office note also? No office note also. Huh? Anybody for the other side? Nobody for the other side also. Parties are not represented. List the matter after 2 weeks.
I beg for your indulgence in item number 20.
20 years.
Your Lordship, if the matter could kindly be fixed on March 26th.
March 26. 20, item number 20.
I've mentioned earlier, my lord, and I.
Okay, then we will have to inform you that other PS. What is your name?
Jassi.
Jassi, you inform.
Yes.
When do you want 26?
March 26.
The date will be March 26.
Yes.
She'll just change the date. Everything is otherwise as similar.
Much obliged.
For orders item number 26.
Office note dated 21/2/2024 indicates that service report on the respondents is awaited. List the matter after 2 weeks.
Item number 27.
Mr. Lordship.
Yes.
As per office note, service upon respondent 10 is
Respondent is awaited.
Respondent number 10.
10. So you need the respondent number 10.
Yes.
Okay. Office note dated, Miss so-and-so is present on behalf of the petitioner, and Mr. Riju Momi
For the state respondent.
is present for the state respondent. CGSC.
No, Lordship.
No.
I'm for the state respondent. CGSC. they
Oh,
are
you present for the
2 to 9.
respondents number 2 to 9.
2 to 9.
Service report on the other respondents is awaited.
Yes, Lordship.
List the matter after 2 weeks. All right.
Lordship, I have a prayer. There's a similar case in WPC 236 23. So
Along with WPC number?
236 of 23. Senior counsel or Mr.
President, respondent number 1. B dot.
Okay, no, Mr. Lam is a senior counsel, chairman, and who's with it? C. Chief. Dash on behalf of Lam is senior counsel, Mr. Non-chairman. Non-chairman. Who that?
It's in the petition name. You're finding the affidavit. Where I was getting that question. Presenting that person.
Item 11 is of my favorite. 5. No, not 5. 11. Just after 5, he has mentioned 11 again. I was in there item 11.
Two weeks may over. 2 weeks. 2 weeks. You find it in the more. Yes. LOMG. J. Also, cancel. B dot. B. ZHI.
It's disposed, cancelled. Cancelled for disposed. Please check. Completed.
Miss, miss.
It's for petition. That one. And which one?
So Koza. খেলা হয়েছে